more incumbent upon the citizenry to act in the form of legislation that tells Google, don't do that anymore, Google, right? Rather than to say that when everybody knows Google's doing it, Google knows they're doing it, law enforcement knows Google's doing it, why can't law enforcement take advantage of something that's readily available that everybody knows about?
Your Honor, it's our position that not everybody knows exactly how intrusive this geofence information or this kind of Google location history data can be. I mean, I personally wasn't aware of how invasive it was until I started researching this case. I mean, it tracks your data, it tracks your location every 2 minutes. It is capable of following you almost like an ankle monitor into every constitutionally protected space that you go, and to give that kind of...
But to talk about it in terms of the capabilities that did not get exercised in this particular case, isn't that sort of like blowing up the whole world for the sake of a bad thing that happened in one spot? You know, I mean, we're focused, I think, on privacy interest at a particular moment in time in a particular geographical space, aren't we? We're not trying to find everything about a human being through this technology.
First of all, we don't know in this case whether it followed any of the suspects in the second stage of the Google protocol into constitutionally protected spaces. That is not in the record. So that very well could have happened. Second of all, like I keep emphasizing, it's the capabilities of the data. What can this data reveal? I mean, I think we don't penalize the user because the government's request didn't happen to stray into constitutionally protected territory.
How widespread is the use of this geofence situation?
I mean, my understanding is that people have been, or law enforcement has been seeking geofence warrants since 2016, and it has exponentially grown every year.
Are there any records of corruption to the information?
Well, there's certainly records of sweeping innocent people up in geofence searches. For instance, there's an example of a person who was riding his bike back and forth through, accidentally through an offense location, and he had a bike tracker on his bike that was clocking in using Google location history data, and he was swept up in a search, and took some time before he could reveal why he was bike riding by the offense instead of part of it.
I thought I read that there were 2 people whose names were acquired that were not connected to this offense. Is that right?
That's correct. There were, the end result was 3 names: Eva Balsagar, Gary Ryder, and Aaron Wells. And those first 2 names, no one knows how they're connected or why they have no connection.
Okay, and as far as your position, I take it you agree with this circuit that
Yes.
Central Office on general warrant, and that it doesn't matter so much what the filter is that's in the warrant as the fact that this entire database is going to be searched every time you do it.
That's correct.
Council, to follow up on that, we're talking a little bit about the third-party doctrine and things of this nature. What is the analytical framework that you were asking us to fit the intrusion into? Like, there was an illusion about should we expect the legislature to enact laws that limit Google's access, but then you've mentioned specifically the idea that we don't expect Google to, or we don't expect that when we give this up to Google, that Google would use it as extensively as they might. Is this something you see as fitting within the reasonable expectation of privacy test? Is this something that we need to consider possibly a positive law situation where we look to see whether or not there's actual legislation or statutes out there that might limit this scope, and those suggest that there's an expectation of privacy? What is the analytical framework that we will be trying to use, assuming there is an intrusion?
It's our position that the third-party doctrine does not apply,
Okay.
and the warrant as is a general warrant.
Okay.
So to the extent that what legislation could do to change that, I don't know. I'm not prepared to speak on that. But the next phase of our argument would be that the third-party doctrine does not apply And there was no probable cause or particularity for the warrant as it existed.
Okay.
Clarify something for me. So the geofencing, that law enforcement essentially gets the location of either witnesses or suspects, which may or may not benefit the case. How do they get to the next step to get all that information? Where does the probable cause come from? I mean, assuming they're going to want to get into the phone after that, correct? Not just the location.
Are you asking about the language of the warrant itself?
Yes.
I mean, first there's the affidavit, the regular affidavit of probable cause, that authorizes the initial search of the sensor vault, the 592 million users in the sensor vault. And then after that, Google and law enforcement are negotiating to see which of those might have some connection to the offense based on their
Because they're there,
judgment.
right? Is that basically it? Because they're in the vicinity. That's
That's
all the
correct.
information they're getting,
Right,
nothing
only
else.
yes, yes, Your Honor.
Isn't that kind of, I mean, when law enforcement typically will canvass the scene of a crime, and will find witnesses people who might have seen what was happening, and ask them questions and get their information, their phone number, their address, their name. They're going to be gathering that kind of information even if they're not using technology, isn't that true?
Well, Your Honor, that would be then going out into the known crime scene or the known active areas surrounding the crime scene and asking specific witnesses. That's going to be different from running through 592 million users to see if any of them happen to be in the crime scene at the time of the offense.
So the way you're proposing this though is that like there's a person combing through this information, it's just a computerized search that meets the parameters. And what about the fact that the geofence warrant doesn't initially target a particular individual? It only reveals anonymized information and then, even that's just for a small area where the crime happened, so how, I guess, what is your take on that? How does that play into this?
Are you asking about whether the warrant has individualized probable cause?
So when you're talking about as a general warrant, not probable cause, it's just that it's like what you're saying, it's part of an investigation, finding out who was there. And so it's not even giving the initial devices there in that time period. And even then, they have to go through a couple extra steps to find out, and narrow it down, and find out who is there.
Well, first of all, we've argued that the extra steps are without court guidance and therefore patently illegal. But as to the initial unindividualized search of 592 million users that produces some anonymized data, I mean, that is the exact hallmark of an unparticularized warrant. I mean, it's overbroad, completely overbroad, with no parameters, no judicial parameters on how that search is done. And there is certainly evidence within the case law that you can determine who those devices are even when they're anonymized, because you're now seeing where they're going.
So how would this be any different though, say if a police officer goes to businesses in the area and requests their surveillance footage?
Well, in that sense, I mean, law enforcement is not going to the business with the aim to determine whether that person's committing a crime. So that's exactly what's happening with the geofence. They're trying to expose perpetrators.
Wouldn't that be what you would find in the surveillance video? Is who committed the offense, who was there, who might have more information?
But you're going to a specific place of business with a known video of the crime scene.
But isn't that what's happening here, is that law enforcement is going to a particular business, Google, knowing that they might be able to reveal information about who was there and help law enforcement?
So I think that is a fallacy in the state's argument that they're substituting Google for the individual users they're seeking to search. Google is not a witness or suspect to the complainant's robbery murder. Google does not own or control location history data, the users do. Google does not generate or keep the location history data the users do. It belongs to the individuals, numerous tens of millions of them, and a geofence warrant seeks to search every one of their accounts. My time's up.
Thank you.
May it please the court. My name is Joshua Vanderslice, and I represent the state in this Fourth Amendment case from Dallas County. This is an exciting opportunity for this court. This will be the first high court in the nation to address geofence requests to third parties. This court's opinion will show practitioners across the state how this court handles novel investigative search techniques. This court is also uniquely positioned to decide the threshold search issue in this case, as Judge Wu pointed out, because it has the opinions of Ward and Sims. And this court took just 6 months after Carpenter to issue Sims, which of course recognized the historical foundations of Carpenter and also the limitations on the exception that it announced to the general rule that there is no legitimate expectation of privacy in third-party data. So the question is this: what is the identity of this court when faced with a novel investigative technique? Is this a court that is going to offer its best guess at Kramer's intent? Or is this a court that's going to look at the constitutional text and examine its own precedent to find an answer to a novel constitutional question?
So here's what's really troubling to me, counsel, is you have a situation where, because I understand it, and please feel free to correct me if I'm stating this incorrectly, but there's a warrant that's issued, which leads to the going and gathering of information from Google about certain devices that might have been in a particular geographic area in a particular moment of time. And then, even after that is done, they've got some anonymous, I guess, identifiers at that point. And then they're, without going to get any further court approval, the law enforcement goes back to the company who provided this information and tells them, I want to know more about this device, without having to demonstrate probable cause that relates to that specific device as opposed to the others.
That entire procedure is described in the warrant, and it's described in the warrant in this case. And so the way the geofence warrant was used in this case, and it's used differently in different cases, but the way it was used in this case was that we provided probable cause for all of the data that we possibly get with the warrant up front. If a phone was in that box, then we had probable cause to believe that its user was either a suspect or a witness.
Is that because it was drawn so narrowly?
Because it was drawn so narrowly. And there's different ways to do it, as I explained in the brief. You could have multiple fences and only ask for data from people who appeared in all of them. But for the way it worked in this case, that process of going back to Google was specified in the initial warrant and was justified by the probable cause that was in the initial affidavit. So that's why we didn't need to go back to the judge.
I'm wondering if you've ever seen, or if you've ever seen a case outside of the technology environment like we have here, where law enforcement gets a warrant that authorizes them to go and search a house, and that if in searching that house they find probable cause that they might find more evidence if they search another house, that the warrant, the initial warrant, would authorize them to go ahead and go on to that next house, since after all they found probable cause to go there when they operated on the first warrant.
I don't think that there's a case like that.
Okay.
But there is such a thing as a triggering provision in a warrant, or an anticipatory search warrant. And so that would be the analogy I would draw, is that if you can tell from the outset that if a given data point is going to give you probable cause for further intrusion, then the judge can pass on that when he signs the initial warrant.
Right, but to some extent though, it's more analogous to saying, I've got a search warrant for a particular house to look for something, and then while I'm doing it, whatever the support I have for searching the house, if it covers the area that's in the house, and I see something that might be evidence in addition to what I was looking for, I would be able to get it.
Exactly.
Right.
In a non-technology context, that's a perfect.
But also, as I understand your argument though, you're saying that you had probable cause go probable cause all the way down. You basically said, this is the most probable cause we have. So the warrant would be justified for the most invasive search when they went back versus just we're getting a small amount. The probable cause only establishes that first initial location question, and then you didn't have enough. You're not saying you didn't have enough money to or a probable cause to establish a second warrant for more information. You put the whole shebang in there. So your position is that there's probable cause for every single piece of Google data that you got from that initial warrant.
What is your probable cause? Because the defense said it didn't have it.
Well, the probable cause, and I think it's important to go over the facts. The probable cause is that a murder occurs in the course of a robbery in the middle of the night. Home security cameras capture the perpetrators coming from a church across the street and shooting the victim's wife in the front yard, and then following him into the house and eventually killing him in the house. The security cameras are just on the outside. They don't show him killing him in the house. The surveillance cameras at the church show the perpetrators, and only the perpetrators, coming from that parking lot, parking the car, they hide it behind the building, they run across the street, and then later it shows them coming back and fleeing in the vehicle. So the officer knows with certainty that this horrible murder has occurred, and he knows the movements of the perpetrators. He knows that only the perpetrators were in that parking lot, but he doesn't know who they are simply because they were wearing masks. And as the Supreme, or not the Supreme Court, but as courts have repeatedly had to tell the KKK, just because you're wearing a mask in public doesn't mean you have a right to anonymity when you're going around and terrorizing society.
So counsel, it may surprise you to know that I'm not the person that was involved in this offense, but why was I searched then?
You were not searched in this whole process. At no point were you searched. And I'm assuming that you're a location history user, because that seems to be the claim that Ms. Dean is making now, at least in this court, that it is a search of every single Google user, or is a claim, or is a search of every single person with location history data turned on. The first thing I would say is that that argument was not raised until the reply brief in the motion to suppress, which was filed after the hearing. And so the judge didn't have an opportunity, and the state didn't have an opportunity to reply to the idea that the search was not just innocent people who might be in the initial geofence, but also everybody who has sensor vault data. So technically the court's opinion doesn't have to reach that question, but I recognize that this is a case with far-reaching implications. And the reason it's not a search of everyone in the sensor vault is because every user with sensor vault data has opted into sharing that data with Google. So while they might have an expectation of privacy in the whole of their movements under Carpenter, and against the disclosure of those movements to the government, it's not an expectation of privacy against Google.
Right, well, what about the idea though, like, you know, I don't know, I probably have hundreds of apps on my phone. And if I go to my Google settings and I turn everything off, but then I go for a walk and I use an app to track my walk, and then that one captures data and I just forget. I mean, you see what I'm saying? You see the danger here is that in no meaningful sense have I consented to having my location shared, because I have 287 apps on my phone, and I've shut the location data off all of them but 10, but I forget the 10. Like, I mean, you see the concern there. How would you address the concern that, like, why do I have to be a cyber sleuth and go get a degree in cybersecurity to figure out how to turn this stuff off on my phone?
You don't need to be a cyber sleuth to figure this out, because it is a Google account level setting. And it's important, and I address this in a footnote in my brief, the difference between general web and app activity that might get reported to Google for other purposes, and the location history data that's at issue in this case. Location history is a Google account level setting that you have to go turn on within your Google account. And in order for it to collect the data, you also have to turn on what used to be known as Google Location Services and have your actual hardware and able to do that. But the account level setting of Google Location History that you go into your Google account and turn on is the only data that we actually get with a geofence search warrant request. And I addressed that, I think, in the first footnote in my brief.
Counsel, didn't the Chattree court find that 2/3 of Google users do not opt in to the location services?
Yes, I believe they figured that out via some affidavits that are in the record in this case.
And do you happen to know what Google's user agreement says, who owns the data that is collected through location services once it's opted into?
I think it's clear on this record that the Google data does not belong to the user. We entered in a lot of Google's privacy documents from the time of this search warrant into the record in this case. And you can just tell from that Google's going to be using this information. And we know that they're going to be selling it to people. So there's no property interest in that data for the user.
So counsel, like that leads me to the question. So is your position that there wasn't even a need for a warrant to begin with because this is searching something that you voluntarily turned over to a third party? Or is it that this warrant was good enough because we had probable cause to get all the Google data?
It's both.
Okay.
But I think it's important that the narrowness of the warrant first supports the probable cause inquiry, but it also is the reason this isn't a search, for the reasons you were discussing with Ms. Dean earlier, but also because to the extent that Ms. Dean is arguing that there's this data is somehow qualitatively different, SIMS says that it's not about the content of the data. That's why it was able to reconcile the factual distinction with the real-time location information.
So
Counsel, if the Fifth Circuit is right, there is, because this database is so big, and it's like a general warrant, there would never be probable cause to conduct a geofence search, right? But wouldn't that apply to other databases?
Yes. I think that's a problem with the Fifth Circuit's analysis. I think there's three major analytical errors with the Fifth Circuit's analysis. But I think on just the threshold issue, this is not a standard you would apply to any other third party. It's not what we would apply to bank records under Miller. It's not what we would apply to any other third party that will have very, very precise information about where you were at a particular time. If you scan in at your gym, or if you go sign your kids out from daycare, or if you open and close a bar tab. Those third parties are all going to have extremely precise information right down to the terminal that you used to make that transaction of where you were at that particular time.
But isn't that different? Because you're talking about face-to-face transactions or me affirmatively going on Venmo and giving somebody $25 for babysitting my kids. But here, I mean, it's passive, right? I mean, you are passively participating in this data collection. I mean, wouldn't you say there's a difference there?
Well, I think you're actively participating in this data collection. Only a third of people have opted into it. That we learned from the January 6 opinions that they ran different geofences. They went back and got another one later. And between the two times that they executed the geofence warrants, there were 70 people who had deleted their location history data. So people understand how this works, and it's not on by default.
So how do you delete your location information? This is wrong.
You can write it down.
Right, did you submit a supplemental reply on how to wipe our phones?
Can I have a serious question? So excuse me, the Fifth Circuit noted in its opinion that the geofence warrant request that was at issue there asked for 98,192 square meters in their geofence geographic area. And it occurred, I saw a photograph, it seemed in this case, or a drawing, that seemed to only surround two buildings in a single city block, one on each side of the street. And I'm not a math wizard or anything, but I thought that's nowhere near 98,000 square meters. And I'm wondering, do you know how many square meters we're dealing with here? And is that something that might be an appropriate reason to draw a distinction between what happened in Smith versus what we're dealing with here?
That is a good reason to draw a distinction because drawing the geofence differently will often lead to a different result. And there are measurements in the record of this case. If you look at Greg Gamble's testimony, not his testimony at the 702 hearing, but his testimony before the jury, he talks about some of the measurements that he took with the measuring wheel. And so there's it's not the entire geofence, but he does measure the distance, for example, from like the area where the car was parked down the parking lot to the street. And I think that was 100 meters.
Okay, so that would be quite a bit different.
Yeah.
I'm concerned about corruption within the data collections. You mentioned January 6th, and there were pipe bombs, government collected information, and corruption. So they didn't get anywhere to figuring out who put the pipe bombs, where they put them. So I worry about corruption in this kind of system as well?
Corruption within Google or corruption within the government?
Well, both, both possibility, but with the data collection and the whole process, do you have any information as to whether that's a concern or instances of that, or?
I don't have any examples of instances of using this for corruption or for.
No. This is in gathering information to try to hone in on suspects and collect data and something happens to it, like it did on January 6th with the pipeline.
I'm sorry, I'm not familiar
I
with
think, I think she's talking about like the data itself being corrupted.
Right.
Oh, I'm not aware of that happening. I suppose you could, you're talking about corrupt, like the file gets corrupted
Right.
that Google sends.
Right.
I suppose you could rerun the warrant and have them do it again. You would still have the same probable cause, presumably.
This might go to the question of scientific reliability.
Oh, the reliability.
Yes.
Well, I think as far as the reliability issue, a corrupted file wouldn't give you like usable information. You wouldn't be able to get up to the jury and testify he was over here if it was actually over there. It's that's I without understanding precisely what kind of corruption you're talking about, it's hard to answer the question. But
Counsel, I wanted to ask you to, I discussed this, or asked this question opposing counsel. In this case, was there information that was collected that goes outside of Constitution, that goes into Constitution, otherwise recognized Constitution protected areas? The distinction being between CSLI gets you basically your movements out in the public. And we typically will say that you wouldn't have an expectation of privacy. Even in Jones, or Knott's, the idea that you're traveling on thoroughfares is open to the public, so you don't really have an expectation of privacy there. But it is worth pointing out, when they take the data and goes into, say, a home or something like that, that would be an expectation. It seems like it would be an expectation of privacy. Even like geothermal imaging or thermal imaging, where you can see the heat signature inside the house. Is there any information in this case that goes beyond sort of movements in public that would otherwise be open to the public that was collected as part of this legal data?
So in this particular case, we captured the public movements of the suspects. That church building that was in the parking lot was the Life Center. They use it as a food bank. So, and he's not supposed to be there at 3 in the morning anyway. So those are his public movements. Now, I suppose you can have a concern that as the fence expands, it might follow people into places that, under a property theory, were previously considered constitutionally protected places. The issue with that is that I don't think this data is giving you anything any more that an officer watching from the street couldn't see. You don't have that concern from Kylo about this is giving us something that the officer can't see without a common law trespass. We're not, a Wi-Fi hit isn't going to tell you when the lady of the house takes her shower, which was a concern of Kylo.
Right.
A Wi-Fi hit is going to show that he went to a house. And that's the same thing that an officer could see from the street without a trespass. And that's the thread, that idea that we're protecting the privacy rights as they existed at the time of the founding.
I'd like to ask one follow-up on that. How is this different from, say, a state act violation situation where basically the idea with the general warrant was, we don't even know if this person in this house has even committed a crime, but we've got a court order, so we're just going to go in there and see if we find smuggled goods. Is there a distinction between that and this?
Yes, because not only do we know a crime has been committed, we have perpetrators that we know exactly where they were, and we know that their movements have already been captured on that surveillance video. That's all in the probable cause affidavit.
But what makes you think that they had location history? You say only a third of users opt in, so didn't that kind of understand probable cause?
In future cases, that was not information that we understood. I think you can tell from reading the probable cause affidavit that was not the detective's understanding when he applied for the warrant. Because at the time, it wasn't until the Google filed those affidavits in Chaptree that we knew that they were not giving us all the information. They weren't giving us they were only giving us the location history information because there were different opt-in procedures, and then it was more granular. That was the only what they say is that was the only information that was being stored in association with Google accounts. So
Location history,
was opt-in location history data.
as opposed to GPS.
Well, GPS hits can be in the location history, GPS, Wi-Fi, etc. But what Judge McClure was talking about, with information that's collected as he's using other apps, that does not go into your location history, so that's not disclosed to law enforcement.
Counsel, I have one question and one problem that I'm having with the very first step of your analysis. Generally, probable cause means probable cause that you committed a crime. If I'm driving by a certain location at a certain time and somebody else does something, how do you get past the fact that there is no probable cause that I committed a crime just because I drove by?
And I see I'm out of time, but I'll answer your question. Probable cause to search does not require probable cause to believe that a particular person committed a crime. That's a thread that we see from the way the rule was formulated in Illinois v. Gates. It carries through Zerker v. Stanford Daily, which states that explicitly about 2 or 3 times. And I even see that popping up in this court's opinion in Baldwin, where it's about the evidence and the likelihood that you're going to find evidence in the place to be searched. It's not about the person. And with those comments,
I do have another question, I'm sorry. I don't want to make it go too long, but I'm curious to know whether outside of law enforcement, are there private companies that are in a position to be able to go to Google and say, we want to pay for information to find out what devices were in a particular place at a particular moment in time, and it's just a financial transaction that's going on out there between private parties?
I'm not aware of that happening at all. And Google, I should make it clear that Google fought this process from the beginning. The whole multi-step process is something Google put up trying to oppose the government from being able to get this information.
Well, this is what leads me to that question is, like I said, I've had experiences with others that we walk into a store and they say, oh, look at that, I just got that advertisement. So it's as if there are private parties that are capable of transacting business with Google so that when a device is noted to be within a particular area, they get that private party's advertisement.
Yes, and that works using location history data and the user's timeline, but it's not a disclosure of mass information to the business. A lot of times the way that works is that there's a Bluetooth beacon in the store, and the Google AdSense knows when a particular user has seen an ad. So if you see an ad, and then you walk into the store, and the Bluetooth beacon sees your phone, then the business knows that there is a person who has seen their ad, and it possibly caused them to walk into the store.
And isn't your information, the information law enforcement getting in your case, also kind of a narrow sliver of information, not all of the information that they could gather?
Correct.
Okay.
And the information the business is getting is completely anonymized and aggregated. It's designed to give them metrics on how well their ads are working. It's not saying this particular person visited your store on this date.
Thank you, Council. Council, do you have 2 minutes left?
Yes, Your Honor.
We gave the state an extra 4 minutes, so you can take more of your time.
Oh, thank you so much. First, I'd like to address the particularity aspect of the warrant and the filtering process. It is our position that there is no individualized or particularized probable cause, that the search affects millions of unnamed people and a subset of identifiable ones that are tracked in the second stage. The second stage, invasions of privacy, are outside the scope of the warrant, negotiated between police and Google or both. And the identification is also the result of a negotiation between police and Google that is not overseen by a court.
So I need to ask, I'm sorry, if you're not finished with that statement, I just want to make sure that, because you mentioned there's no particularized probable cause.
Yes, Your Honor.
And I think there's different ways of looking at that question, right? So one way of looking at it would be, do we have probable cause that a particular individual committed a particular crime at a particular place on a particular day? No, it doesn't seem like they had that. But they did have probable cause that a crime was committed, and that it was committed by people who were in a specific geographic area. And it seems like it was drawn, the geofence that was drawn was minuscule in relation to the geofence warrant that seems to have been at issue in Smith. And so I don't know, convince me that I'm wrong to draw the conclusion that there is some particularized probable cause, at least with regard to the location of a particular crime.
When I say particularized probable cause, I was talking specifically about the nexus. But to answer your question, our position is that it doesn't matter how tightly you make the temporal and geographical boundaries. It doesn't matter because there's no judicial guidance on how to proceed.
Well, that's on the second step though, right? I mean, is that what, I heard you be arguing the last time, that your concern is that what I voiced when I was questioning counsel for the state, that you have a warrant at the front end, and then you have information that's gathered, and then probable cause developed, but no second sort of filter through a judicial or magistratorial filter, if you will, in going forward to that more private information.
I may be misunderstanding what you're asking, but it's our position that there was no individualized probable cause to look through the accounts of the 592 million SensorVault users, which is the 1/3 of the people who have their location history data enabled. And then there was no particularized probable cause because there was no nexus between the accounts and criminal activity at the time and place of the offense. And then we're saying that no boundary could circumscribe the area enough, temporal or geographical, because there was no judicial guidance on how to proceed.
Counsel, do you agree with the state that pursuant to the Google user agreement that Google owns the data that is gathered for location history?
Your Honor, no. And I think there is language in the general privacy policy that the data belongs to the user. Because they go through this entire discussion of how you can manipulate your Google location history when you're creating your private map. You can delete pieces of your private map, so it might show what you did for a period of a week, blank, and then another week. So I would have to double check, and I'm happy to file a letter brief. But I do think that the privacy statement says that the Google location history data belongs to the user.
Let me follow up with this.
And that is how it is de facto.
Okay, if when you check that agreement and if you happen to find that pursuant to the Google user agreement that the data actually belongs to Google, then do you lose standing here?
No, Your Honor, no, that is not our position at all, because in no way does the language of the privacy policies or even the more specific location history policy explain how much they're tracking you, how intrusive, how frequent, what the retrospective capabilities are. No, it's our position that the data has so much depth and breadth and intimacy that there's no way that the user could understand what it is that they're enabling.
Counsel?
Yes.
Okay. Counsel, on your second issue, we haven't talked about it at all, but Judge Kirby sort of alluded to some discussion about the danger of corruption of data and reliability of Google data. On your second issue, with regard to the admissibility of expert testimony based upon this data, did the court below have the benefit of our decision in Null versus State, which talks about how we analyze the reliability of particular data that an expert is relying on, and whether that opinion can come in based upon particularly reliable data?
That decision issued after the court made its ruling in this case, but it's our position that that's very different from our case, because in Null, you're talking about 2 accredited labs that have regulations in place, versus in this case, you're talking about law enforcement and a commercial behemoth that's unregulated. And also, I know that there's a distinction in Null about quantitative versus qualitative, and this is not quantitatively sufficient, much less qualitatively sufficient, because we don't know what that data is. We don't know anything about that data that was supplied.
Anything else?
I think I'm going to thank you for your time, and I'll rest on my brief for the remaining concerns.
We're going to adjourn the court shortly, and we're going to leave for about 5 minutes or so, and we'll be right back for a Q&A session. So the case is submitted, and then we'll adjourn the court.
The Honorable Court of Criminal Appeals now stands to recess, subject to the call of the presiding judge. All right.
Salavropoulos. And this has been a fabulous, wonderful event for us, including everything that happened yesterday and what's going on this afternoon. And we didn't do the work. Everybody else did the work. So Salavropoulos has been our most gracious host. And I want to thank the criminal justice section for putting this all together. And it's been the best ever. We've done this before, and this has been the best ever. I also want to thank the attorneys who came all the way out to Far West Texas to argue this case. I'm so glad they did, and I hope they enjoyed themselves being out here, because I know this is one of my favorite places in the world, and I hope they enjoyed it too. And the bailiff, and the timekeeper, and the sergeant at arms, and the people over here who were doing the recording. Everybody has been so gracious and done so much for us to put this on. I also want to thank Dina Williamson, our clerk, who probably didn't know when she became clerk that her primary duties would not be filing cases, they would be arranging social events and all that she really has learned how to do that. She didn't know before. So, thanks to everybody who has been involved in putting this event together. Now, we take questions from the audience, and if you don't ask questions, we will just take turns talking. If anybody has a question, please raise your hand. And don't be shy. Yes?
So how often does the court travel, and how do you decide where in Texas you'll be hearing cases?
I'll take that one because it's an easy question. We travel once or twice a year, and we've done it ever since I first became presiding judge 30 years ago. Sometimes we get invited by different law schools or high schools, but mostly one of the judges will say, hey, we haven't been to so-and-so for a while. In this case, some of our judges had not been to this part of the state, and I wanted to make sure that they saw it, how wonderful it is, so I suggested it. And my suggestion was taken up at the criminal justice session immediately, and they put it all together. Questions? Yes.
How do you all assign cases among you?
Which that Judge Richardson or Judge Perkins? Go ahead.
Randomly. Well, it depends on the type of case it is. The death penalty cases come in on a wheel, so one judge doesn't get stuck with too many death penalty cases. But then, if they come in as a PDR, petition for discretionary review, they're assigned to a judge. We vote on whether or not to grant review on it, and then those who are in the majority to grant can be assigned the case.
On a rotation basis.
Yes, it is.
And then also, if too many of us have, or if any of us have like too many cases in our chambers that we're working on, they might skip us on that rotation, which generally goes, I believe, by order of seniority, and each goes judge by judge in order of seniority until the cases are decided. So it's random, but there's a couple of caveats to it.
So also, if there's a judge that, the initial vote is to refuse, and a judge writes a dissenting opinion on the refusal, and then the vote then changes to grant, then the judge who wrote that dissenting opinion is automatically assigned, typically is automatically assigned to write that opinion.
And sometimes Google makes it.
The consequence, one of the consequences of random assignment is that a judge might be assigned a case to write a majority opinion for the court, who might not be capable within their own conscience of writing that opinion that would please a majority of the court. And so that judge then has to write a majority opinion, bring it to conference, lose the vote, essentially, and then it can be reassigned to another judge at that point to write a majority opinion that the court can get on board with.
And that's because we don't conference on every case. We have post-submission conference on cases that are argued, but on a non-argued case, our clerk will assign it to the next judge in line on rotation.
And we don't pre-assign, so in other words, cases today haven't been assigned yet.
Yes, in the back?
Oh,
Oh. Yeah, that's fine. No, go ahead.
Thank you. How many requests you receive in a year, and how many requests will be granted for appellate court hearing? That's one. Secondly, we are visiting from Mongolia, and just recently, maybe 2 or 3 years ago, we adopted so-called discretionary rules. But many people, many lawyers, are unhappy about this new introduced rule in Mongolia, and I just wonder whether public in Texas, people in Texas, happy about these discretionary rules, and what lawyers and judges looking at these rules. Thank you.
Sure. As I understand your question, you're sort of asking generally how many cases we get and how it is we decide which cases, or how we decide whether to grant discretionary leave or not. I mean, in other cases, we actually have a docket that's split up in a lot of different areas. Death penalty cases go directly to us. I can't give you exact numbers off the top of my head, but those are few and far between. But we'll have several of those that are on our docket a year's time. We'll get 1,000 or 2 maybe requests for discretionary review, and then we'll have another part of our docket is our writs of habeas corpus, which happens after discretionary review, after a case has been affirmed, and those are by far the biggest part of our docket. The total amount of cases we generally see is anywhere from 6,000 to 10,000 cases a year, with greater degree of introspection and things of that nature. But when it comes to discretionary review, the cases we decide, when we try to decide whether to grant or refuse, we have rules that basically look for things, they're 4 basic ideas. Does the lower court's opinion conflict with other courts of opinions or our opinion? Are their cases inconsistent with, is the lower court's opinion inconsistent with the Supreme Court, with the case we decided, with even another court of appeals? Also, the case like we saw today, if it's a really novel issue that needs to be decided, hasn't been decided, that's something we'll do as well. And sometimes, in a very small number of cases, there will be, also there might be, well, there's a statute that's never been interpreted. And so that's the third thing is, well, we need to interpret the statutory provision or a constitutional provision. No one's ever done that, so we have to do that. And then lastly, in a small number of these cases, the courts of appeals will maybe do something, you didn't quite get that one right, we need to correct that. And so there's a small exception for us to do that. But those are the basic things. We try to get the big issues that are going to affect everybody. We try to resolve conflict between lower courts so everything is unified. And occasionally we try to fix some errors that we saw below.
But as far as discretion is concerned, we have no discretion with the death cases.
Right.
They come to us. And we have no discretion with the writs. And post-conviction, we have to take all of those. The discretion we have is with the cases that come on are now 15 courts of appeals, whether to take those or not. So, and usually we grant between 7 and 10% of those. But again, the biggest bulk of our work is post-conviction.
And of course, sometimes the parties are disappointed if we don't grant review in their case. But we take into account all the things that Judge Newell mentioned, plus other things. And so, yeah, we usually grant only 7 or 8%.
It might also be important to highlight that, because you mentioned how people are dissatisfied with the new rule of discretionary review. And I don't know about how it works in Mongolia, but here in Texas, you have an appeal of right. You have the right to an appeal to one of our intermediate court of appeals in the state. That's not a discretionary appeal. That first opportunity to appeal is they have to be afforded that right to an appeal as long as they comply with the rules and file it timely and so forth. It's only when you go to the high court, only when you come to our court, where we have discretion to not review certain cases because we don't think that they measure up to what we think is too important enough for us to address.
There was a question in the back. Is there still a question?
Yes, how do you determine what cases get heard, like for oral arguments? And then how long will it take y'all to make a decision about the arguments, in theory?
Did you know the answer how we make decisions about oral arguments?
So if a party asks for oral argument, I vote for oral argument. But I'm only one vote, and it takes 3. So you've got really to persuade 2 other judges on the court if you ask for argument. in order to get an opportunity to appear before the court and argue your case. And that's how it works, at least the way, from looking from my little window on this 9-person world that we live in.
And we hear arguments typically on the first and third Wednesdays of every month. And not for a couple months in summer and not even much during December. But that's what we reserve those days, those mornings for our arguments.
And check out how long it takes to make it.
Oh, how long it takes? It varies. Some death penalty cases typically take longer than non-death cases, but there's some very complicated non-death cases. And a case can be assigned to a judge who doesn't get the majority, and then it has to get flipped to another judge who has to start and do the whole appeal process from the other point of view. So there are a number of variations in how long it takes.
We have a hostage rule.
Yeah.
We also have a hostage rule that ensures that if someone doesn't like an opinion that seems to have the majority vote, you can only pick it up for so long. And you can, the rule is 3-2-1, right? So if someone is dissatisfied with an opinion that's come into the conference and would like to write something to complain or give another point of view, then that person, the first person who decides they want to do that, can only hold on to that case for 3 weeks. And it has to come back to conference then. And then the next time somebody does that, they can only hold it for 2 weeks, and then it has to come back. And the last time, only 1 week, and it has to come back. And the problem is by then, somebody might have persuaded someone else that the proposed majority shouldn't be a majority. And so you have to flip, and then you have to kind of start the process over.
And one thing I'd like to add also is that, as you heard, we have a huge volume of cases, most of them being the post-conviction writs. We're one of the busiest appellate courts in the nation. We receive about 3 times the number of filings as the Texas Supreme Court does, and we issue about 3 times the number of opinions that they do annually.
Yes.
Please. Lift her microphone, yes.
First, I just want to say thank you so much, Justice Keller, for selecting Sul Ross State University. We really enjoyed having you here. My question is, given the magnitude of the cases that come before this court, why are they limited to only 20 minutes on each side?
I would like to know the answer to that too. Because I could have spoken to these lawyers all day long.
If there's a discussion going on among the judges and lawyers, we let them go on until easily 10 minutes longer, 15 minutes longer. But and that often happens actually.
And also, we receive briefing from the attorneys, and of course, we're the final stop. So there's been a trial, there's a record from the trial court, there's been a review by the Court of Appeals, so they've written an opinion on it, and then we get additional briefing from the attorneys if we grant discretionary review. So we have a lot of information that we can already review and go off of, and so usually the oral arguments are more to ascertain some nuances or some remaining questions that we may still have.
Also, a lot of work goes into getting ready for oral arguments. So all of this reading, and despite what the public thinks sometimes, we're reading it all. If you had gone into the room this morning before we came out, the silence, everyone was still looking at whatever documents they had. But then we're on the bench, and then we conference after we're on the bench. And so a lot of work goes toward those cases, and we still have a pile of stuff in our office that we have to address. So it's not a situation where you don't want to hear from the lawyers. We're just really, really, really busy.
I would add to a couple of things on that. In the sense that the 20-minute limit is sort of arbitrary, but experience has sort of taught us that really gives us a nice sort of gauge about what's going to be productive versus what's not going to be productive. I can say that since I've been on the board and some of my colleagues here too, we actually had a pretty significant case from where Rip Perry was indicted, and we had an oral argument. We stated that argument out with 2 different parties. I want to say it was like 30 minutes aside, and we had them argue about the same points. And in those kinds of situations, we'll make allowances, but even in that case, I would say, we may have given more time than we needed. And it really did emphasize to me at least, that, too much is, that brevity is the soul of it, or, less is more.
I guess,
Yeah, can I ask that, I want to thank y'all again too also, but given the magnitude of your cases, can you talk a little bit about your staff and what role they play? And also maybe giving some ideas for our students of like the legal profession and what kind of opportunities or job opportunities that might be available for the
I
board.
think that's not answered a question yet.
All right. So each judge, so we sort of have two flavors of staff. So we have what's called central staff, and they are kind of the first eyes on things that come into our court. And those are lawyers, but they're also non-lawyers who do things for central staff as well. And then each judge has a staff of 3, a recent law school graduate, usually a recent law school graduate. It's usually with us for 1 year, maybe 2 years. What you might call a permanent attorney that's with you all the time. And then we have an executive assistant that basically is sort of a traffic cop, a kindergarten teacher, kind of older woman, and make sure that, things don't get missed and timelines aren't missed or cases don't just disappear either. And so, there are a variety of functions in the court with my staff. I'm the one sitting here wearing a robe, but I can't do it without them. They're super important to me. And I can't do my job without them. So when I took office with no staff, and I was completely lost. And Judge Keller had to basically let me rent out some of her staff to help me get up to speed on the fire alarm. But there are a lot of opportunities with the court, and obviously one of the reasons why we're here is, we want to emphasize that these are good careers, and I think the court, easy for me to say probably, but I think the court's a great place to work. And so anyone who wants to talk to us about that, afterwards, please.
I want to add, so too, we were actually in the district particularly, we were lucky to be able to bring some of our staff with us so that they were at the networking yesterday with booths, so that they could talk to people about possible job opportunities. And a lot of people think of lawyers as being advocates in court, and being a research attorney, for example, is examples of a lawyer that doesn't necessarily go to court, but does a lot of legal research. And I think all of us would say the same thing, but I'm very lucky to have the staff that I have, very lucky to have my staff attorney, very happy that she's been come here with us today. And I wouldn't be able to do my job without her. She does all the smart things, and I do all the dumb things.
Our central staff is incredible as well, very helpful, brilliant lawyers. And also we do have interns. So I've been in the court for 150 years now. I've had high school students as interns, or college students, or law students as interns. They don't get paid, but at least they can, experience criminal law and what we do as a court. And, we make a few things besides make copies and make coffee and stuff. And actually, perhaps help us draft something. So we encourage people, if they're interested at all, they might be in it for no money, but for the experience to ask for a position.
We also have a clerk's office, and that's another career path opportunity for people that are interested in the justice system, but maybe don't necessarily want to go to law school. And our clerk's office does a terrific job. They handle a huge volume of cases. They keep track of things. And Dina's not the Lone Ranger. Thankfully, she's very happy to have people that help her do her job. And it's a lower profile aspect of the court, but it's certainly very important, vitally important to the court's function.
And speaking of that, I think in case any of your students would like to interact with us, can we please have the court staff stand up and wave so that everyone can see who you are and people can come and ask you questions?
Thank you, Judge Lauren. I think we're running a little bit behind schedule, so unless there's anything else, I'm going to call her into the Q&A session. And yes.
Can I take a picture now?
We're going to take pictures.
Can I take a picture right here?
Somehow.
Oh, sure.
Okay, I didn't know if I was going to.
And I neglected to recognize the Mongolian delegation who came here and joined us for the time that we're here, and thank them for coming, and just really special that you're here.
And this delegation are a bunch of judges from Mongolia also, so that's really special to have them here with us.
Okay, Dina? Yes, let's do this.
Down.